Lawyers, what's a law that isn't real that normal people insist exists? It's a law that exists, but widely misunderstood, is the concept of entrapment. If the police put a bait vehicle in a high crime area, that is not entrapment. If the police are watching a bar known to overserve to see if there are impaired drivers at the end of the night, that is not entrapment. Entrapment only occurs when a gov agent suggests committing a crime that you were not otherwise going to commit. It's federal law US that a plainclothes or undercover police officer has to identify themselves as law enforcement if asked. No, it's not the law, and they can tell you whatever the freak they want. Probate attorney here. I've heard many people ask me when the reading of the will is going to take place. I explain to them that only happens in movies. But one of these days I'm going to have one and hire a mysterious blonde wearing a veil to sit in the corner quietly. Then I'll tell everyone that she inherits everything. Provided, of course, that she must adopt the decedent's cute but troublemaking 6-year-old child no one knew about. Or she can spend the night in a haunted house. Her choice. In the UK, that it is illegal to drink under the age of 18. You can buy alcohol with a meal at 16, beer, wine, cider, and you are not breaking any laws if you give your child some alcohol in the privacy of your own home and they are over the age of 5. In the UK, it's not illegal to park on someone else's driveway. It's classified as trespassing, a civil offense, not criminal, which means the police can't do anything. This particularly surprises people as many think that they have exclusive rights to the parking outside their house as well. The one that is the most frustrating to me, even though it's not really a specific claim that a particular law exists, more a rule of evidence, is that's just hearsay. You have no evidence. Comes up all the time, in all kinds of contexts. Even lawyers love using it when it suits them. Nothing but hearsay and speculation. Usually, what people mean when they say that is don't believe them. They're lying. Which, fair enough, but that's not what hearsay means. Lots of evidence is just a person talking. That's what a witness is. It's why testimony exists. It's not evidence, just because it's a person talking. Hearsay just means that in most cases, you can't have person A say that person B said this in order to prove that this actually is true. Hearsay, get it? I heard B say it. It just means your witness can only talk about things they actually know about. And, extremely importantly, it also doesn't count as hearsay when person B is actually the person on the other side of the case. Person A is totally allowed to say person B told me yes, I will commit the crime on Tuesday if person B is the defendant who has been accused of committing the crime on Tuesday. You don't get to complain it's hearsay if you're the one who supposedly said the thing they heard. US ex-lawyer here. There is no law that requires the police to provide you with their name and badge number when asked. There may be internal policies, but it's not the law. There is also no law that requires the police to get a supervisor if demanded. Again, policy versus law. There is no law that allows you to question whether an order given by the police is lawful or not. A court has to decide if the order was lawful after the fact, but there are laws to punish you if you do not comply. In my country, some people believe they can press charges against someone. You can't. You report a crime and the police decide if they are taking it further. It's not up to you whether charges are brought. You may want charges brought, but the police drop the case. Alternatively, you can refuse to press charges and the police can bring a case anyway. It's harder without the victim or witness cooperation, but they still can. You do have a right to civil cases, of course, but when people say press charges, they believe they can do this via the police. In the UK, people often claim that if an item is listed for sale in a shop, then the shop legally has to sell it to you at that price. This is not true at all, as the shop doesn't have to sell you anything at any price. Often as a gesture of goodwill, shops will honor erroneous prices, but they are under absolutely no obligation to do so. I'm not sure if this would technically be a law or not, but the way tax brackets work, I've repeatedly heard people in retail or construction say something to the effect of, I'm going to turn down this shift because if I take it, I'll go up into the next tax bracket and so will pay more in extra taxes than I will earn from taking the shift. The tax system is specifically designed not to do this. Here's an example of how tax brackets actually work. Say there is a tax bracket at $10,000. The rate below $10,000 is 5% and the rate above $10,000 is 10%. People seem to think that if they earn $9,999, they will pay 5% of that, $499.95 in taxes, but that if they earn $10,001, they will pay 10% of that, $1,000.10 in taxes. How it actually works is that you pay 5% on the first $10,000 and 10% only on the dollars above $10,000. If you earn $9,999, you pay $499.95. But if you earn $10,001, you will pay $500.10. You earned an additional $2 and paid an additional $0.15 in taxes. 5 cents on the $10,000th and 10 cents on the $10,001st. Of course, there are all sorts of weird interactions between taxes and government programs. Especially when someone is receiving certain government benefits, it is totally possible for each dollar you earn to be taxed back 1 for 1, or worse. In that case there is a genuine disincentive to work more hours. But for a normal worker thinking about how many hours they can work before they end up in a higher tax bracket, you will never earn less by working more. So just work as much as you like. The legal limit for back in drunk driving. There is no such thing. The common refrain you hear, especially from media outlets that have no idea what the fuck they are talking about, is that there's a legal limit to the amount of alcohol you can safely have in your system and legally drive a car. No. Simply no. It doesn't exist. There is a statutorily established Paresi limit in every state. This means that if you are driving and your back is over that limit, you are Paresi intoxicated, and the state doesn't require any more evidence to convict you. But if you are under that limit, you can still be convicted of drunk driving or driving while intoxicated. The state will have to provide additional evidence to do so. So, even though you've just had one, or have a back under the legal limit, you can still get arrested and convicted of drunk driving /DWI/OUI, or whatever else your state calls it. Now, but here's one that bounces around legal advice every couple months. The age of majority in Mississippi is 21, so people say your parents control your life until then, and you can't move out without permission until you are 21. The truth is that the law means they have an obligation to provide for you until you are 21. You can move out at 18 and not face any penalty or be forced to return. Although the age for Mississippi emancipation is officially 21, this only refers to emancipation from a parent's obligation to support their young adult financially. In Mississippi, individuals age 18 and older may vote, enter into legal contracts, take legal action against others, and be sued for damages. Similarly, an individual age 18 or older who moves out of his parents' home is not considered a runaway in Mississippi and is not legally required to return to the family home. Circumstantial evidence. Often pop culture portrayal of criminal law tries to draw a distinction between hard evidence like blood at the scene or a weapon in the suspect's possession from circumstantial evidence, such as what a witness heard or mismatched entries in a calendar that contradict an alibi. How often have you heard a TV suspect, when confronted with some facts, say that's all circumstantial, it's not enough to convict me? The viewer is left with the impression that the facts presented don't matter and that the law weighs circumstantial evidence less. In reality, the law doesn't afford any more weight to one type of evidence or another. There isn't even a formal distinction in criminal rules between the two. There is an academic distinction. Hard evidence, also called direct, is based on direct observation and doesn't require any explanation beyond the facts themselves. Circumstantial evidence requires some inference to arrive at the important fact to be proved. For example, a witness testifying that he saw the suspect stab the victim is direct evidence of the action of stabbing. But that witness could then testify that before the stabbing, he heard the suspect demand that the victim hand over his wallet and the victim refuse. This is circumstantial evidence of motive. You can infer that the suspect then stabbed the victim because he wanted the wallet and didn't get it when asked. Circumstantial evidence is often vital to establish certain criminal element like motive that can't directly be observed. But there is no get out of jail free card just because evidence is circumstantial. If your wife hears you plotting to kill her and sees your axe sharpening equipment in the attic, your neighbor finds your copy of How to Kill Your Wife and Get Away with It, and you write an email to your brother saying I'm going to do it tonight, that hoe cooked my steak well done, you're probably going to jail for murder. It's irrelevant that you destroyed your axe, cleaned the basement perfectly, ensured no witnesses, and fed the body to pigs. Circumstantial evidence can be enough. I think one thing we should definitely point out is, just because something isn't technically a law, doesn't mean you can't get arrested for it. At least in the US. And, we should always point out, that the United States has more laws than they even know exists, and law enforcement is not required to understand any of them. So, just because Google claims something, doesn't mean it is true, or will hold up. I suggest anyone who is dabbling in law, illegal or legally, give this video a watch. He goes over multiple things, including the 27,000 page book that has all of our laws and no one has read. He also goes over how certain things don't even need to be illegal in your state, or in the US. There are laws that state, if something is illegal in any country, they can charge you for it, and, of course, the main topic he discusses is why you should never speak to law enforcement under any circumstances. Even if you're 100% innocent, you say nothing. People's notion of freedom. Don't get me wrong, I'll be the first person to argue against the slightest infringement of our constitutional rights, but you don't get a free pass to be a dick under the guise of freedom. For example, the First Amendment, really the entire Bill of Rights, applies to state actors. Absent some anti-discrimination statute or other generally applicable law, if you find some non-govt actor has inconvenienced you or offended you in any way, it's not an affront to your civil liberties. So when a private company like Costco says stay off my private property unless you have a mask, James Madison isn't rolling in his grave. Late to the party, but haven't seen it mentioned. Basic contract law is something most in the UK do not understand. If they see a drink on a menu, priced at £5, and then they take the menu to the bar and order their drink and it turns out to be £6, they will insist it is their right to pay the price on the menu. I even once had a girl try to claim she was studying a law degree and I must legally give her the drink for the advertised price on the menu. I had to tell her that I was literally in a class that covered this exact thing that same day. A contract requires an offer and an acceptance. To assume the menu price is the offer that is accepted by the customer is wrong for a multitude of reasons. She may be completely twatted out of her mind for one, in which case the barkeep must be allowed to refuse her drink. The drink may also be out of stock, so through no fault of his own the barkeep may be in violation of the contract before they even interact. She may want to buy more drinks than the establishment can even have on site. 120,000 pints of ale anyone? No. The customer must offer to buy the drink for a price and the barkeep can accept or decline. That is the offer. The customer must accept his price or try to haggle on whatever ground they like. The menu price perhaps, but the barkeep can refuse for any reason at all. He could be out of stock, so unable to offer the menu price. It could be old POS material that has been left on the table and he can refuse to offer on that grounds. He may even simply not like her attitude, in which case he can politely tell her that he also studies law and she needs to read Pharmaceutical Society of Great Britain v Boots Cash Chemists 1953. As a former gun shop owner I have to. 1. Just because I allow the public into my store doesn't make it a public space. 2. I don't give a damn how many background checks you pass or if God himself enters the store with you. I have zero obligation under any law to sell you anything. Also, civil rights laws are often misunderstood. It is perfectly legal for me to refuse to serve a black person or a religious person or a disabled person, etc. What I cannot do is refuse a sale because they are black, religious, disabled, etc. They might sound the same, but they are legally two massively different things. A sale is an agreement between two parties, the store and the customer. You offer to purchase an item at the price I display, and I decide whether I want to complete on that offer by accepting. I don't have to accept, ever. Since most people aren't lawyers anyways, I'll post one. Just because a law is on the books still doesn't mean it isn't superseded. I live in the American West, and yes, there is still a law that hasn't been struck down where I live that if more than 3 Native Americans are off the reservation and armed, it constitutes a war party. But it's superseded by like a million other laws and common sense. You can't just go a lynching. However, finding that out, my buddies did name their 3-piece metal band War Party because technically they were. Like and subscribe for more Reddit videos.